Welcome, everybody. We'll get started shortly. Okay, great. At least we got the same hair vibe going on. I keep mine tucked away right now, but
I know, big, crazy. That's how I'm
Yep.
feeling. Always under a hat.
Yep. We'll give it just a minute. I think it's better to get started and folks can kind of pick up where we left off. But yeah, well, once
Zach,
I see it hit.
Where did we leave off on the regs?
We're on part 119, so just about to enter into municipal. And I'll introduce that too. After I introduce you. Actually, I'll point it to you. You introduce yourself. All right, well, good morning and welcome everybody. This is the adult use regulations read through presented by and supported by Cannabis Association of New York. That's CANY and the Rochester Public Library. This is session 2. We're picking up where we left off as we're beginning to enter into the municipal rulemaking. That'll be page 25 for those of you who are following along in the reg printout or PDF. Before we jump in, we got a few folks that will be joining us today to be offering their professional perspective. The idea of this platform is to read through the regs in a community setting that allows for a diverse group of perspectives. And in this case, as we're in this comment period, the 60-day comment period that allows folks to ask questions to the OCM for clarification, et cetera, we hope that this read through allows us all to better understand what's being proposed, find places for clarification and or recommendation for best practices, et cetera. So I will pass it over to my co-host, Jason, allow him to introduce himself, and we'll keep going from there.
Thanks, Zach. I'm Jason Klemick. I am the chair of the policy committee for CANY, as well as the leader of the cannabis team for Barclay Demon. Pass it over to Elise to do a quick introduction, and then we'll dive in.
Hi, everybody. My name is Elise Bergio. I am a general counsel for MJI Solutions and Marriage Industries, which are 2 women-owned businesses here in New York. I also am on executive leadership for NISBA, also a member of the policy committee for CANY. And I'm happy to re-kick this off. We did this last rollout.
Yeah, great. My name is Zach Sarkis. I'm the chair of the education committee for CANY, as well as working alongside the library to help building out their cannabis programming. Also a cultivator, a small business owner looking to find a way in this place. So we bring some legal background, some experience background, best practices moving forward. If you have questions, feel free to drop them in the chat, the Q&A, which you can find down below. We'll take questions in stride. And usually when there's questions, it allows for the best, most robust conversation. So don't hesitate to, there's no wrong question here. And if you're watching this recap, we thank you. Just stay tuned. We'll be releasing these. We'll be doing Tuesday, Thursday moving forward until we're done. It's going to be from 12 p.m. till 1:15 on Tuesday, Thursdays. And again, this is number 2, and we will dive right in. Just going to share my screen here. All right, so we are picking up in part 119, municipality rulemaking. And we'll cover a lot around the zoning, around what's allowed, what's not, how communities can establish their framework and their operation standards for this evolving industry. So we'll pass it back and forth. I'll start with the reading. Jason, I'll tap you in a little bit and feel free to stop me at any point in time. So preemption and prohibitions on municipality rulemaking, part A. So pursuant to section 131.2 and 85.12 of the cannabis law, the governing body of a city or town, a county, town, city, and village are preempted from adopting any law, rule, ordinance, regulation, or prohibition pertaining to the operation or registration, licensure, or permitting of a registered organization, adult use cannabis licensee, or cannabinoid hemp license. The board prohibits municipalities to pass local laws and regulations governing the following activities. Adopting local laws that impose a special fee that is specific to cannabis business on the approved licensee that intends to operate within their jurisdiction. Adopting local laws that impose a fee on adult use retail dispensaries or on-site consumption license, except where the fees are also applicable to off-premise liquor establishments licensed under the state liquor authority prior to the 31st of March 2021, and such law does not conflict with the cannabis law or this part. Are you guys aware of any examples of that where there's a special fee for like a liquor store?
I'm not.
No.
Jason?
Yeah,
Yeah, no.
No, I don't know, but I would just say that the first one there is important because we saw that crop up right after the kind of opt-out period and stuff like that. Is some municipalities are trying to basically tack on their own fee, sometimes like several $1,000s, and that was very concerning. So it's nice to see that addition to the regs to make it very clear that
Yep. Agreed. Appreciate you outlining that. So 3, adopting local laws that impose a tax or fee on cultivation, processing, manufacturing, distribution, or sale of cannabis or cannabis product in this state, other than the usual and customary fees associated with similarly situated businesses. Adopting local laws that prohibit a premises for which an adult use cannabis retail dispensary or on-site consumption license has been issued from being located within a distance to be measured in accordance of 119.5, this title that is no less than 1,000-foot radius from another premises from which the license of the same type has been issued in a city, town, village, having a population of 20,000 or more. No less than a 2,000-foot radius of another premises for which the license of the same type has been issued in a city, town, or village having a population of 20,000 or less. And then adopting or I guess that was it.
Yeah,
I'm curious here.
Click on that.
Yeah.
So this is a very interesting new component of the regulations. This was not part of the MRTA. And it's created, I would say, more restrictions, obviously, for people who are entering into the retail or on-site consumption space. Obviously the biggest feat right now for cannabis dispensaries and on-site consumption is going to be finding real estate that meet the specs of the 500 square foot, 200 square foot rule, and now this 1,000 or 2,000 square foot radius, which makes you in heavy competition against people in your area that are going to be looking for real estate. When you see dispensaries, so a lot of times they're cluttered into certain areas because of zoning within that jurisdiction for purposes of where commercial businesses can take place. So,
and we're already starting to see some of this. If you read through the card delivery guidance, it says right in there that if they want to open a retail dispensary, as opposed to just their delivery location, and they chose New York City, any of the boroughs in New York City as their top choice, despite the fact that OCM said you're located in your top choice. So if you picked Manhattan as your top choice and you were selected, that's where you were supposed to go. OCM said you can now choose any of the, 4 boroughs because Brooklyn isn't joined. So we're already starting to see where a lot of these dispensaries may be crowded out or things like that, that they opened it up to all the boroughs of New York City as opposed to just the one that you were licensed for.
Yeah, it's a big thing, especially in a small town. It's like, if there's one dispensary, a 2,000-foot radius, and a 1-street town or a light town, it's like you can see how quickly it pushes the edge of what's applicable, what's possible. Very much substantially reduces the opportunity for business. And especially when we're talking about places with Buffalo who have existing nightlife districts that are focused hubs for retail for alcohol. So it's like if imagining designing something like that for cannabis, which would make sense, competition is not a bad thing. As we've said, you go to a McDonald's, you guarantee, and you're going to look around, you're going to find another fast food store within visual distance. And that's just kind of, competition has always been a thing. So I'm curious to see how that'll be addressed moving forward.
Also, you look in the city of Rochester or a lot of the towns, it's exactly what you said. They have their bars kind of on one stretch, and that's okay apparently for bars, but for cannabis dispensaries, they're taking that authority out of the municipality and saying that the state is mandating it. And, you know, I don't know whether that's maybe the best choice or just let the municipalities decide for themselves.
Another big thing with this is the issue with, like, for example, I think Long Island is a really good example of this. All of these localities that have been opted out and are taking away, you know, it's almost more than 50% of New York has opted out locally. So Long Island, it's like what, 4 localities that are permitting cannabis to be dispensed or have on-site consumption. That is not gonna, this specific regulation is not going to permit that many dispensaries, and the card licenses are already being awarded in Long Island. I think somewhere between 19 and 21 different licenses. And so that's going to probably take up all of Long Island, honestly, on dispensing. I don't know if you'll be able to find anything in the general that meet this zoning requirement.
Yep, that's a big thing. So just thinking out the gate, that is first come, first serve. You know, first to market really has a huge leg up with that kind of. Again, you add the 500 feet from a religious center or a school, et cetera. It's like you really look at these pockets. If we're creating zones, radiuses around potential areas, it's very prohibitive.
And just the tough
right,
part about
go
this
ahead.
is whoever gets licensed first wins, right?
Yes.
So I'm assuming once they award that license, even provisionally, you're going to be opted out if you were second in line and now you're within 900 or 1900 square feet per the, you know.
Yep, big thing. All right, so 5, adopting, municipalities shall not adopting or be prohibited from adopting or executing any agreement where the municipality, community organization, or association affiliated with such municipality otherwise receives any additional benefit outside general operation for imposes a duty of obligation on any applicant, registrant, licensee, or permittee of the board. So essentially that's saying, you know, it's not no pay to play outside of the existing model. We've seen a lot of cases where people are taking money from businesses that kind of show up as corruption charges in the long play. So I kind of feel like that's what that's alluding to. Adopting a local law that should deny any right, privilege, permit, variances, approvals to any licensed adult use retail dispensary premises that has been in existence continuously from a date prior to the date when the building on the same road or street within is 500 feet of said licensed adult use retail dispensary premises has been occupied exclusively as school grounds. I think exclusively is an important thing to note there. 200 feet of said licensed adult use retail dispensary premises has been occupied exclusively as a house of worship. 500 feet of licensed adult use retail dispensary premises has been occupied as a community facility. And then dispensary shall be in a location consistent with public convenience and advantage standards as determined by the board. And the board may issue a license pursuant to this section for a premises which shall be within a 2,000 foot radius of an existing premises license and operating in a city, town, or village having a population of 20,000 or less pursuant to this section after it determines that granting such license would be of public interest. So that's them kind of coming back full circle for the 20,000 or less, which is interesting, but I'm curious why they chose not to have that same thing for the 20,000 or more.
It also just, to me, just doesn't make sense why they want to burden themselves with this. I mean, this is clearly municipal zoning, and having to get OCM approval is just another step that has to be done, and also more, you know, overhead for them. You know, they're trying to ramp up this whole industry, make sure everything's going smoothly, and this is yet another thing that they're going to have to deal with, as opposed to just letting the municipality deal with it, which the municipality deals with zoning all the time. That's one of their big functions.
And just this expansion of community facility, which again is new, wasn't in the MRTA. Again, makes more restrictions on what you can and cannot be within that 500 foot range with.
Jason, you want to take this next section?
All right. authorizations for municipality rulemaking. All municipalities and counties are hereby preempted from adopting any law, rule, ordinance, regulation, or prohibition pertaining to the registration, licensing, permitting, or operation of registered organizations, adult use cannabis businesses, or cannabinoid hemp businesses, provided, however, such municipality may enact local laws and regulations governing the time, place, and manner of the operation of a licensed adult use cannabis retail dispensaries and or on-site consumption sites, provided that such law or regulation shall not make the operation of such licensed retail dispensary or on-site consumption sites unreasonably impracticable. Remember that term. That's a term that is going to probably be thrown around a lot when people start applying, as determined by the board. To the extent that the following is not unreasonably impracticable, the board authorizes municipalities to pass local laws and regulations governing the time, place, and manner which shall mean and apply to the following activities. The hours of operations for a retail dispensary during which cannabis products can be sold at retail, which shall not be allowed to operate from 2 a.m. to 8 a.m. unless given express written permission by such municipality, or the municipality passes a local ordinance authorizing it to operate beyond such hours, and shall not restrict operations to less than 70 hours a week, provided, however, that this provision shall not be construed as removing the licensee's discretion to operate for less hours of operation. The hours of operation for on-site consumption site during which cannabis products can be sold at retail, which shall not be allowed to operate from 4 a.m. to 8 a.m., shall not restrict operations to less than 70 hours a week, provided that this provision shall not be construed as removing a licensee's discretion to operate for less hours of operation. Business operations within historical districts, parking, traffic control, including but not limited to pedestrians and vehicular traffic, odor, consistent with Public Health Law, Article 13E and the Clean Indoor Air Act, noise, and distance requirements between a licensed premises and a community facility, provided, however, that such distance requirement is no greater than 500 feet from the licensed premises to the community facility. This provision shall not apply to licensees operating pursuant to Part 116 of this title. That's CARD, by the way.
Did we go over the difference between door to door and grounds?
We
With
have not. So if you want to mention that, go ahead.
Well, is it,
Point.
can we go up? Is it in that 500 section, or is it in the definitions? Just because I wasn't on the definitions.
Pretty sure it was in the definitions. Let me check.
Yeah. Because this is important. This is a big difference between, again, what was in the law versus what was in the regs.
So yeah, in the definition, it's part 118.175. School grounds means any building structure and surrounding outdoor grounds, including entrances or exits contained within a public or private school, nursery school, elementary or secondary schools, legally defined property boundaries as registered in the county clerk's office.
So school grounds is obviously a much more difficult standard, especially when you look at like fields, right? You think about a field that goes behind the school, another 2 acres. It's a much more wide range and restriction there.
Right. And house of worship means a whole building owned or leased by a religious corporation. So it doesn't necessarily mean the grounds. And I believe, though not my area, that in alcohol, it's not school grounds. It's actually measured from the door, not the boundary. I think that is how it is in alcohol.
And that's just another one of these things where we keep finding these cross examples where cannabis is held to a higher standard than alcohol is. And given that cannabis is substantially safer from a public health and safety perspective, we look at death, accessibility, et cetera, like you got to at least imagine there's opportunity to comment and ask, why should cannabis be held to a higher standard or a different standard? and or recommend options that are more equitable or at least on the same tier of standard that the alcohol license is. We've been using that as a reference to justify, like, is this too extreme for cannabis? Or can we tailor it back or make it match what the alcohol looks like as just a starting point?
Particularly when you look at the rationale for a lot of things from OCM, that they are pulling a lot of this from the alcohol. So if they're using it for alcohol already, they're not creating this out of whole cloth, they're not creating a whole separate regulatory scheme, then why are they changing it from alcohol? And why wouldn't they then, change alcohol going forward to match this? Like, why treat them differently if you're saying we can treat them the same from a regulatory perspective?
Yeah. You want to keep going with point 3?
Sure. All right, notifications to municipalities. Pursuant to section 76 of the cannabis law, notifications to municipalities regarding adult use retail dispensary or on-site consumption licenses shall be in a form provided by the office and contain the following information: applicant contact info, trade name or doing business as name, full name of the applicant, street address of the establishment, including the floor location or room number, if applicable, the mailing address of the establishment if different than the street address, the name, address, telephone number of the attorney or representative of the applicant, if any, a statement indicating whether the application is for a new establishment, a transfer of an existing licensed business, a renewal of an existing license, or an alteration of an existing licensed premises. If the establishment is a transfer of a previously licensed premises, the name of the old establishment and such establishment's registration or license number. In the case of a renewal or alteration application, the registration of the license or license number of the applicant and the type of license. I do believe actually these forms are available now on the OCM's website. I think I saw them, so you can kind of see what they're going to look like. A municipality shall have 30 days from the receipt of the notification from an applicant to express an opinion for or against the granting of such registration, license, or permit application, and any such opinion shall be part of the record upon which the office makes its recommendation to the board to grant or deny an application. Provided, however, a municipality may request additional time in writing and upon showing a reasonable documented effort for an extension. So this is just another thing that we've kind of been saying for a long time of you got to kind of get your municipality on board with you, because they do have the option to say nothing, but they also have the option to give you a thumbs down, and obviously a thumbs up is going to be the best of all of those choices. So it's really important that anybody looking to locate within the municipality is kind of doing what apparently didn't happen too well in New York City with the community boards, with the card licensees. So you really want to get the municipality on your side, show how you're going to benefit them by being there and benefit the community and things like that. It weighs heavily.
Yep, thanks for that. Elise, do you have any interest in reading? You can pass. I can take up the mic or whatever.
Sure, I'll read for a bit. Okay, so 119.4 is the measurement of distance. This is what we're talking about, guys. Measurement of distance from school grounds, house of worship, community facilities, and between adult use retail dispensaries and on-site consumption premises. So no adult use retail dispensary or on-site consumption license shall be granted for any premise which shall be 1, on the same road and within 200 feet of a building occupied exclusively as a house of worship. 2, on the same road and within 500 feet of school grounds. 3, on the same road of a community facility if the municipality has enacted an ordinance in accordance with section 119.2 of this title. In a town, city, village having a population of 20,000 or more within 1,000-foot radius of another premise for which a license of the same type has been issued. So now that's interesting. Are we considering on-site and dispensaries? Obviously not the same type of license, or maybe we are, because now dispensaries are allowed to have on-site consumption lounges technically. So this is kind of an interesting, we might want to highlight this for same type issued. Does that mean it's just a dispensary if you're going for a dispensary license, or does it mean dispensaries and on-site consumption are in similar type issuance because they're also both under the same category anyway? So in a city, town, or village having a population of 20,000 or less with a 2,000-foot radius of another premises for which a license of the same type has been issued. The measurements in subdivision A of this section are to be taken in a straight line from the center of the nearest, so everybody understand, the center of the nearest entrance of a house of worship or the nearest point of school grounds to the center of the nearest entrance of each such premises licensed and operating pursuant to this section 72 and section 77 of the cannabis law. Except, however, that no renewal license shall be denied to any premises at which license under this chapter has been in existence continuously from a date prior to the date when a building on the same road and within 200 feet of said premises has been occupied exclusively as a house of worship. A house or worship of 500 feet of said premises has been occupied by school grounds. So what does that mean?
So it's basically say, go ahead.
I was just going to say, so this means that it's, you know, in law, we call this the nuisance law, right? So if you're coming to the nuisance, which in this case, and not like we're nuisance, right? But that's just the way that it's defined. If you have a dispensary that was already licensed at the point of the first application round and you had done your due diligence, you were not within any of these confinements within restriction of square feet, but afterwards, say after within the 2 years now that you've been operating, a house of worship pops up next to you in the building next door because they don't have to do the same type of zoning requirements, then you're still within that correct zoning because they came to the nuisance. They attracted themselves next door to you after you've already been licensed. So you're in the clear there. So within the context of this paragraph, the entrance shall mean a main door of a house of worship or of premises licensed and operating pursuant to this section, regularly used to give ingress to the students of the school, to the general public attending the house of worship, and to patrons or guests of the premises licensed and operating pursuant to this section or of the premises sought to be licensed, except that where a school or worship or a school or house of worship or premises licensed and operating pursuant to this section or the premises sought to be licensed is set back from the public thoroughfare, the walkway or stairs leading to any such door shall be deemed an entrance, and the measurement shall be taken to the center of the walkway or stairs at the point where it meets the building line or public thoroughfare. Such definition shall not include cellars, back inside doors, delivery entrances, or emergency exits. There is a website that the SLA publishes. And I don't know, Jason, if you have access, or Zach, to it easily, but it does let you put in your address and it'll show if there's a house of worship or a school, or I don't know if community facilities are included in on this, because I think that's an expansion of a definition. But you can type it in and you'll see what you're close to kind of generically on this SLA website. If the school or house of worship or premises licensed and operating pursuant to this section or the premises sought to be licensed is located in a multi-story building, the building entrance at the road level is used. If the school or house of worship or premises licensed and operating pursuant to this section or the premises sought to be licensed is situated on a corner lot, such establishment is considered to be on both the roads of the intersection, whether or not there is an entrance to the building on both roads. So a door which has no exterior hardware or which is used solely for an emergency or fire exit or for maintenance purposes, or which leads directly to a part of the building not regularly used by general public or patrons is deemed not an entrance. So within this context of the section, a building occupied as a house of worship does not cease to be exclusively occupied as a house of worship by incidental uses that are not of nature to detract from the predominant character of the building as a house of worship. Such uses as including but not limited to, scroll it, the conduct of legally authorized games of bingo or other games of chance held as means of raising funds for nonprofit religious organizations which conduct services at the house of worship or for other nonprofit organizations or groups, and the use of the building for fundraising performances by or benefiting the nonprofit religious organizations which conduct services at the house of worship or other not-for-profit organizations or groups. The use of the building by other religious organizations or groups for religious services or other purposes. The conduct of social activities by or for the benefit of the congregants. The use of the building for meetings held by organizations or groups providing bereavement counseling to persons who have suffered the loss of a loved one, or providing advice or support for conditions or diseases including but not limited to alcoholism, substance use disorder, cancer, cerebral palsy, Parkinson's disease, or Alzheimer's disease. The use of the building for blood drives, health screenings, health information meetings, yoga classes, exercise classes, or other activities intended to promote the health of the congregants or other persons, and use of the building by non-congregant members of the community for private social functions. The building occupied as a house of worship does not cease to be exclusively occupied as a house of worship, where the not-for-profit religious organization occupying the house of worship accepts the payments of funds to defray costs related to other parties' use of the building. So you're going to see this a lot, you guys. For anyone who's actually looked at locations outside of New York, because we really haven't had to deal with this other than in the alcohol space, houses, like a room in a house can sometimes be determined as a house of worship. Very, very random areas, which you wouldn't think. It's not obviously just this traditional structure of a church, temple, or any other type of house of worship. It can literally be something as small as a nonprofit was formed as a religious organization in a house next to a building. So really have to do your due diligence on this in the house of worship. You want to kick that off, Zach? Sure
do. All right, unreasonably impractical review and determination. So part A, pursuant to section 131(2) of cannabis law, in accordance with this part, no rules, regulations, ordinance, or actions of the municipality shall be effective or enforceable if such an action otherwise impedes on the duties and obligations of the board as set forth under the cannabis law, violates any provision of the cannabis law of this part, or discriminates against or frustrates the registrant, licensee, or permittee's ability to carry out the operation of such registration, license, or permit issued by the board. I'm curious what frustrates means in that case. Like, I mean, I can assume, but it's just like, is it if it makes you annoyed, or is it if it, makes it really hard to do your business? Obviously, like, there's a range there.
Well, I'm sure most businesses would like it to be annoyed. I think it's kind of, it harms your business's ability to operate.
Yep, makes sense. B, should an unreasonable and practical claim be brought before the office by a claimant contesting that the validity of such a local law or regulation, the board may conduct a review of such law and issue an advisory opinion as to whether the law is unreasonably impracticable. Upon review and determination of the application to the board, the office shall send a copy of the advisory opinion to the claimant and the municipality from where the local law originates. Should the law, 1, be adopted prior to the advisory board opinion, the claimant can use the advisory opinion as a prima facie evidence of the board of the board's opinion that the local law violates cannabis law section 131(2), or be proposed but not adopted. The municipality shall be preempted from adopting the local law, as the local law, if adopted, would be unreasonably impracticable as determined by the board pursuant to cannabis law section 131(2). So what I'm hearing here is, like, if there's something that feels sketchy, or do you feel it will prohibit your ability to do business from a municipal level, notify the board immediately and request a comment. And if they can provide a statement before anything's put into motion, that then they should be they would not be able to implement that law, or am I misinterpreting that?
I think you're correct, because if it's proposed but not adopted by the municipality, then it's preempted. If it already gets adopted before the advisory opinion, then you have to go back to the municipality and say, no, this is preempted.
Is preempted? Is this the wrong word? I mean, just sorry to interrupt you, but be proposed but not adopted in municipality shall be preempted or prevented. I feel like they're trying to say prevented, but it's
kind of the same thing.
Oh, there we go.
I will say this, that before they even get to this part, local jurisdictions have been in constant contact with the OCM right now on how to roll out, at least the bigger localities, I would say, have been on this rollout with what they can and can't do pursuant to the cannabis law, because I think what we're seeing is a lot of these localities, and I get it a lot, Jason, I'm sure you do too, where we're getting municipalities approaching us, asking us how they can adopt and move forward on their laws without being in violation of the MRTA.
Mhm. And I mean, the legislature didn't make it easy because they used concepts that don't have any kind of analog really in municipal law. Like time, place, and manner is a First Amendment thing. It has nothing to do with law or real estate. And unreasonably impracticable, to my knowledge, that's not something that's common in real estate. So they kind of developed these two concepts, and now municipalities are like, okay, well, what does this actually mean, and how can we implement this and not violate the law? And so there's going to be, I think, definitely a learning curve here for everybody trying to get this right. But hopefully we will have, as that happens, we'll develop more guidance, and so people can be more assured as to what is and is not allowed.
Yep. All right, so final piece of the municipality section is 119.6, severability. If any provision of this part is or its application to any particular person or circumstance is held invalid, the remainder of this part and its application to other persons and circumstances shall not be affected thereby. All right, and then we're moving on to the next section, which is application and licensure. Part 120. So we'll start with general application authorization and slowly begin to make our way through the different license types, the fees, etc. So this is where it gets interesting, folks.
I want the group to understand that there's a very strong difference between what you have to apply with versus what you will have to show when you have your provisional license. So make sure you're paying attention here on what's actually going to be required once that app window opens. And then once you're awarded, what then you'll have to show within a 12-month period to get your license up and running.
Got it. So that'll be the threshold that you have 12 months to actually get it. So yeah, we'll dive into that more shortly. All right. So 120.1 general application and license authorization requirements. Applications for a new license type and for additional licenses of existing license types may be accepted from time to time as may be deemed appropriate and necessary. Licensing applications shall be accepted, reviewed, approved, and issued on a continuous rolling basis. Limitations may be imposed on the acceptance of licensing application, including but not limited to the total number of licenses, the location or authorized region of operation, the size of operation or output, and operating conditions such as sustainability, public health, safety, and social and economic equity factors.
I think is important is a lot of those things are not going to be readily available to the public. I mean, obviously you could look up like the licenses in a given area, but that's, still going to be sort of difficult. So hopefully OCM will put out that information, because if you're going to go in and you're going to pay, the non-refundable application fee, you're going to hire somebody to do it, you might want to know some of these factors so that you can do some analysis as to whether or not, like, where you're choosing or what type of license has some type of, reasonable success rate. So I hope that OCM does publish that data so that people can look at it.
Cool. Thanks, Jason. 1 second here. All right. A licensing application shall be accompanied by an application fee in the amount required by this chapter for such a license in the form and the manner prescribed by this office. An applicant may use an electronic signature on an application which shall be deemed intended by the application to have the same force and effect as a signature affixed by hand. An electronic signature shall be an electric sound symbol or process attached to or logically associated with the electronic record and executed by or adopted by an individual with the intent to sign the record in accordance with the cannabis law in this chapter. So licenses authorizing the cultivation, processing, distributing, and retail sales of cannabis and cannabis products may be granted, suspended, canceled, revoked, and otherwise limited as may be deemed appropriate or necessary. An applicant and licensee shall have an obligation to ensure that the information, documentation, attestations, and assurances submitted to the office are not fraudulent, false, or misleading. An application shall identify any conflicts of interest, including without limitation, any relationships or affiliation of the applicant or its true parties of interest that currently exist with any member, employee, consultant, or agent of the office, the Cannabis Advisory Board, or the Cannabis Control Board. The conflicts of interest may be actual or perceived. If any conflicts should arise from them during the application process, the application shall notify the office in writing of such conflict.
So, Zach, let's
Go
highlight
ahead.
that whole section. That true party of interest is by far the most complicated component of the regulations by a mile. It's something that you really need to vet through with every single person that is going to be component of your business structure. And as we continue to move on through here, you're going to see how true party of interest is not just people who have monetary interest in your business, but anybody who has any type of basically decision-making powers or authority within your company. And so it's a very intricate component, and even reading the actual or perceived conflict of interest is a very, very broad interpretation, because somebody that you might not think has any decision-making power in your company, the board might say that they do have decision-making powers in your company and they're part of other businesses. So this is, if you're going to spend your time analyzing something in the next few months, I recommend it being TPI.
Yeah, this was easily one of the more complicated portions of the card applications. You always have to go back to the TPI definition. And then there's always people trying to like circumvent it by, oh, well, we're just going to form this entity and do this. And no, OCM goes back to the human. So it's very hard to circumvent.
Mm-hmm.
All right, great. A person shall hold a valid license or permit issued pursuant to the cannabis law to cultivate, process, distribute, deliver, dispense, offer on-site use, test, research, sell, or any other licensed activity for adult use cannabis and cannabis products in New York State. The information furnished in the application and in any supplemental statement related to thereto shall be presumed correct, and all shall be binding upon the licensee as if correct. All information furnished in the application or supplemental statement shall be deemed material in any prosecution for perjury, any proceeding to suspend, cancel, revoke a license, or impose a fee or other penalty, and the approval or denial of a license. Applications for adult use cannabis license. An applicant and each true party of interest in an applicant shall provide information in a form and manner as prescribed by the board, which may include but not be limited to the following. The identity of the applicant and or true party of interest. If the applicant or true party of interest is an individual, the individual's name, the date of birth, corroborated by a copy or valid photo identification containing the individual's date of birth issued by a local, state, or federal government, which identification shall indicate the individual to be at least 21 years of age. The name of spouse of any, social security number, contact information, and any other aliases or names by which they have been known to conduct business at any other time. If the applicant or true party of interest is an entity, including but not limited to a partnership, limited liability company, or corporation, trustee of a state, for each entity, the following information shall be provided: the name, the address and principal place of business, the telephone number, all website, social media ties, internet presence, and digital applications on platforms owned, operated, and controlled by or registered by the applicant. If not a sole proprietor, state of incorporation or organization, contact information and the designation of individuals upon whom service shall be provided, federal employer identification number, other names by which it has been known or conducted business at any time. And for each individual partner, member, manager, or non-member manager, director, officer, trustee, certain shareholder, and each individual true party of interest of the applicant, and each level of the applicant, each level of ownership of the applicant, the name, Age corroboration by a copy of a valid photo identification containing the individual, the date of birth issued by a local, state, or federal government, which shall indicate the individual be at least 21 years of age. Citizen or permanent residence status, the home address, the name under which the person will conduct business if different than that legal name of the applicant, including but not limited to applicant owner and financial disclosures, the percentage of ownership in financial interest and any other interest held in the applicant by the persons and the applicants of a list of all parent companies, subsidiaries, affiliates, predecessors, and successors of the applicant, including but not limited to all individuals of each foregone and each level of the ownership foregoing. Jason, can you please take over?
Jason, before we kick off, I think like some of those components of the list are important to remember, right? Like, so I think that a really strong indicator that they're going to try to limit outside TPI and ownership is with citizenship, residency, obviously where all your parent companies hold it, any of these associate businesses that you're going to have to identify, where are they located, what do they do? And for those who are obviously paying attention, there is a lot of litigation happening right now surrounding the Commerce Clause, which gives preferential treatment, or they're saying prohibits interstate commerce by making residency requirements or things that give preferential treatment to New York residents. Most states give preferential treatment to their local residents, but you do it in a way that doesn't violate the Commerce Clause, and that can happen in a myriad of ways. And one of that is with things like showing citizenship, showing where your companies are, and being able to approve licenses based off these documents.
One thing that I would note too is this is right in the law, is that if you are a corporation. So if you're a partnership, which includes LLC, everyone has to be a U.S. citizen or permanent resident. If you're a corporation, your entire board has to be, I think it's the entire board, or no, sorry, I think it's a majority of the board, and all of your officers have to be U.S. citizens and corporate or permanent residents. So, I mean, they're really limiting it to United States. Like it's hard to be a foreign owner unless you're a very, well, you couldn't do it in an LLC, and in a corporation, you're going to be just a shareholder.
Yeah, which I definitely think is the reasoning for a lot of restructuring for like Canopy and all of these other businesses that are in New York. All these Canadian companies looking to enter into the New York space are going to have a really difficult time.
Mm-hmm. All right, so we left off on 4. Okay. 3 or 4. Okay. A description of any and all ownership changes between the original application and the date of submission, including but not limited to events such as asset sales and purchases, stock sales and purchases, mergers, business combinations, or consolidations involving the applicant, including all former names of the applicant. Copies of business formation and organizational documents, such as a certificate of incorporation, certificate of limited partnership, certificate of authority, articles of organization, charters, bylaws, partnerships, operating agreements between 2 or more persons of the applicant that relate in any manner to the assets, property, or profit of the applicant, and any other comparable documents and agreements that set forth the legal structure of the applicant to relate to the formation, organization, management, or control of the business, and all the amendments and changes thereto. That's a lot of information, but it's also super important because I have totally heard so many people say, well, we'll just do this on the side and we won't tell OCM. Bad plan. They have the right to see all that stuff. They even, I believe it's in one of the other guidances, have the right to have a summary of oral agreements. And basically it comes down to, if they catch you doing something that you didn't report, your license is on the line. That's really at the end of the day what it is. So, you can try to get around it, but if you get caught, you can get your license revoked, and you can get what they are calling in the enforcement regs I think it's debarred from the whole industry. Basically, they can ban you from the industry and contracting with anybody in the industry. So if you're debarred, you can't necessarily contract with a licensee to do something. So they have some pretty big sticks to kind of penalize people with if they want to.
And just remember that if you have any violations or any penalties against your license in New York State, if you're ever going to go outside of New York State and try to do something in a different state, when you apply, you have to submit that as part. You'll have to show that you have businesses in other states. You'll have to show you're in good standing of that license in that state. And even if it's a management service agreement, anything that has been issued to you by a state regulator will have to be submitted for any type of application.
And vice versa here. If you bring on partners or you yourself have a license in another state, they're going to ask you about that, and they're going to see if you have any violations. And it's not just cannabis violations. They want to know if you have any labor violations or any other kind of violations that has been assessed against you by some kind of agency. So it's really important to, vet investors coming in and say, are these people going to potentially jeopardize my ability to get a license? So very important stuff. All right, continuing on. Personal histories or an entity history is applicable. Disclosure forms including but not limited to a person's residence, employment, licensure, and conviction history. If you want to see these, download one of the personal history disclosure forms off of the OCM's website. You'll see everything that you need to provide. All proposed or executed contracts, term sheets, agreements, or side letters between the applicant or its true party of interest of the applicant and a goods and service provider other than those exempted under 124.3A1 of this title, or any other party that relates to the ownership and control, structure, assets, liabilities, real or intellectual property. That's an important one because that brings in brands to this whole idea. Administrative, operational, financial advisory, or management services, revenue, funding, or capitalization, royalties, or profit or future profit of the applicant or proposed licensee or comparable documents. Basically, if it deals with money, they want to see it. Capitalization tables showing ownership above 10% of an interest in the applicant, including all owners of all parent and holding entities relating back to all of the individual persons involved, including any person with a vested future right. All right.
Zach, are we letting people ask questions too? Obviously, this,
Yeah.
this is complicated stuff. Yeah.
If anyone has any questions, so just folks who are clear, like we're past our goal with regards to how much ground we wanted to cover. So there's more room for talking. If you have any questions here, this is complex. Again, there's no dumb questions here. So please feel free to ask. We can elaborate either briefly or in depth. And just for the sake of pulse check, can folks, someone from the audience say something in the chat just to make sure that it's working? I know we had some trouble with that last week. I see that I just, it may not have been on, so I apologize. But boom, great. Thanks, Jen. Jen, you're awesome. All right, cool. Well, the chat is now on. If you had any questions, hopefully they're still in your mind. Yeah, let's keep on cruising. It is definitely complex here.
Yeah. And one of the things too, like when I've done this in the past, is cap tables and an org chart to kind of make things a little easier to understand. It's, they are asking for a lot of organization. In my experience, the easier you can make it for them to understand, the less likely it is to get held up.
And mind you, they want to know passive investors too. So even those people who are not at 10%, passive investor, I believe, is 5%. In
a publicly held company.
Yeah. So if obviously a cap table and an org chart really helps for you to understand where all the money comes from and who can activate, these levels of TPI and when they activate.
Yep. All right.
Cool.
Continuing. Oh,
What happens? So Beth asked, what happens between the 5% passive and the 10% investor? So
Good question.
it's a good question. I think that they're going to need to provide more clarity. That's a good question, because I think they'll need to provide more clarity on this, especially because of the broad definition of true party of interest. Obviously, the definition of passive investor means that they don't really have any hold on the company in terms of any decision-making processes. But in the event that this passive investor does have decision-making components, their TPI may be activated and therefore will need to be submitted on the application. And so those are things that we're definitely going to have to ask in public comment period because of this. I think personally, the subjectivity of who does and doesn't have decision-making power.
That's the key, because we can go back to the definition of passive investor, which is 118.161, means a person that is a true party of interest of a licensee with an aggregate ownership of no more than 5% of the outstanding shares of a publicly traded company, or 20% of the outstanding shares or equity, whether such interests are current voting, future voting, current equity, or future of the licensee, and does not otherwise have any control or influence over the licensee. So that right there, it sets up an interesting, as Elise was kind of saying, an interesting question of, well, what is influence? If I'm a 20% shareholder that is quote unquote passive, I technically can't make decisions. I can't control things. But on the other hand, if I'm a 20% shareholder, but I gave you all of your money, maybe I have some influence that, you know, I might not have it on paper, but if I suggest something, maybe that's, you know, kind of more than a suggestion, because I can bankrupt your company if I want to pull my money back.
Well, and it's also interesting to note that, if I'm not mistaken, there are not limitations on how, it may be a horizontal limitation, but you can be passive investor in a multitude of different businesses. So like one company, one person could, I think it's unlimited passive investment in companies. If I'm not sure if it's higher, like if it's still in the 2-tier, like you have to just do it on one side or the other.
It is still in the 2 tiers, Zach. So you can't have a passive investor who has grow or processing in one tier and be a passive investor in a retail store.
Yeah. So then going back to what Jason said, like imagine one investor doing like, I don't know, like 20% in all of the licenses. Well, that's naturally undue influence, you know? So beginning to look, if we break it down in a couple ways, like, should there be barriers of that? I'm not so sure, but it's like, again, a company could go in with like having that kind of offline or long-term play influence. It's a curious structure given everything else we've seen in the language of these documents.
And I mean, obviously, like, so when you do engage your attorneys and things like that, these operating agreements are so important, or depending upon what agreement you're doing, because this is all going to come down to voting rights. You know, any type of, like, this language will be so specific if you do take on passive investors, that they genuinely are almost in between a financier and a passive investor in terms of what they're going to be permitted to do. Because obviously, if you know, your power is held just by having the notes to make the business profitable, that's, yeah, just as Jason said, that can easily be considered undue influence and having decision-making power. So the determination for who you're taking on and at what percentages should really be done with people who understand this law quite a bit, because you are not going to be able to get around some of those things with just the types of transparency that'll be required in the app.
That's so important, because we saw early on people who were we didn't have a lot of guidance, but I think a lot of us who kind of knew what was going on and had experience were not comfortable with a lot of the provisions that, you know, maybe investors wanted that would in other businesses be completely normal. Like, you know, they want the ability in an LLC to appoint the managers. Well, when you were an AUCC and had to have 51% control, that's not going to work. And so you see those things where, like, it starts to kind of, maybe one isn't control, but when you start adding them up, they're control. And again, very, very common provisions for investors who obviously do want control. If I'm giving you $1 million and you have unilateral control, I really need to trust you, because you can drive that business into the ground with, say, from nobody else. So, you know,
And on top of that too, like, I mean, and we see this a lot, right? You get a form on the internet for your business or what have you. And you know what, sometimes that works and that's fine. In this situation, you're going to struggle if you have more than just one or two people in your business that are putting up the money and are activating as TPIs to do something on a formulated basis and not in a subjective, really detailed analysis. But also on the flip of that, and you'll see this, there isn't that much that is necessary to apply for actual license. It's really when you get to that provisional license. So really, when you're ponying up cash for a lawyer, accountant, or consultant, it's going to be on the TPI analysis and your drafted formation documents before you apply. That's where your money is going to come into play.
Great, appreciate that.
Somebody who's done it a whole bunch of times, like, don't
Mhm.
discount the fact that experience and somebody who is completely objective, it really helps. All right, moving on to number 8, or Roman at 8. Documents relating to the ownership structure of the applicant showing all holding and parent companies, subsidiaries, and affiliates. Financial documents, including financial statements and tax documents of the applicant for the most recent fiscal year ending prior to the date of application, the application is submitted, or any other comparable documents as may reasonably be required. If the applicant was formed within the year preceding the application for licensure, provide financial statements for this period of time the applicant has been in existence and any pro forma financials used for business planning purposes. I think that's interesting that OCM wants to see business plans. Because honestly, who are they to evaluate whether your business is like your business plan is good? And also, in my experience, business plans have limited utility. Most people don't make business plans that say, well, I'm going to fail in 2 years. So
is there risk of it, like, sorry to interrupt you, but like risk of intellectual property or something? You know, if you submit that document that has all your everything in it and you give it to OCM, like, is there liability on them, or you know, is it just, I don't know, I could see there being risk there.
You can mark them as exempt from FOIL, the Freedom of Information Law. But I have no idea whether that would protect some OCM employee from stealing your awesome idea.
I also think it's funny that they're looking for these pro forma financials, but don't want an address, right? To like apply with. You don't really have to show like your business, your lease agreements or anything like that. So really, how are you going to draft a pro forma for something when you don't actually have all the documentation surrounding like your real estate or things of that nature? I just find that funny, but
yeah, and I mean,
a more provisional aspect in my opinion, but
and pro formas are going to be, you know, as long as they're reasonable. You know, if they say, you know, within the next year I'm going to make some reasonable amount of money, who are they to say no? I mean, if you say you're going to make 10 billion in 1 year, yeah, maybe they raise an eyebrow, but I don't know what utility that really has. So just my kind of soapbox for a minute. All right, an organizational chart indicating the ownership structure of the applicant and all persons who have decision-making authority, control, and management over the applicant or entity or its assets, including any board members, officers, and directors of the entity, and any parent, holding, or management companies of the applicant. If the business entity has a parent company, include the name of each parent company's principal officers and the percentage ownership of interest of each principal officer. And I'm still curious. I don't know what director means in this context. Is it just referring to board of director, or is it literally
we talked about this a lot, right?
Yeah, is it the
director in
of
a
marketing?
business? Yeah.
Social media director?
Yeah,
Right.
exactly. Yeah.
So yeah, I don't know. We'll find
I mean, a director is literally like could be mid-level. So if a mid-level associate's having TPI activated, that's just bonkers.
Yeah. A description of any license or authorization in any other state or jurisdiction, currently or previously, to cultivate, process, manufacture, distribute, deliver, or sell cannabis or cannabis products in any form held by the applicant or any of its true parties of interest of the applicant, and the following, which may include, but not be limited to, a copy of each license or authorizing document verifying licensure in the state or jurisdiction, a statement granting permission to contact the appropriate regulatory agency that granted the license or authorization, or to authorize the office to confirm the information contained in the application is true and accurate at its discretion, and if the license or authorization was ever denied, suspended, canceled, revoked, or otherwise sanctioned, a copy of documentation so indicating or a statement that the applicant or true party of interest of the applicant was so licensed and was never sanctioned. Details of any administrative proceeding or any governmental agency action in any jurisdiction during the past 10 years in which the applicant or its true parties of interest of the applicant were fined, disciplined, sanctioned, or the equivalent, came to a settlement agreement regarding a potential violation, or had a registration or license canceled, suspended, or revoked, or managed or served on the board of a business or nonprofit organization that was fined, disciplined, sanctioned, or the equivalent, or had the registration or license canceled, suspended, or revoked. So again, important that you vet everybody who is going to be involved in your business who is disclosable to OCM. And I think it's always a good thing that you make them sign agreements that, they will keep you aware of any changes or anything like that, because ultimately it comes back on your license. Information relating to a business continuity plan, which shall mean a plan in case the applicant, its owners, or its true parties of interest decide to leave the business, there is a material change in the applicant's ability to operate the business, or the applicant becomes otherwise unable to operate the business. A certificate of good standing or status from the governing state agency of the state of the formation, certificate of assumed name, or certificate of authority to do business in New York from the Department of State, if applicable, if the applicant is a foreign business where applicable. Information regarding any relationship, agreement, or arrangement that may exist between A, the applicant or true party of interest, and B, any official or any other individual with control over the approval of the application, including but not limited to employees of the office and members of the board. Whether the applicant or any true party of interest of applicant is out of compliance with general obligations law, section 3-5032, I think off the top of my head, I think that's child support obligations, if I recall correctly.
They had that in the card, I believe.
Yeah.
Support.
And I think
That
also the
yeah.
maybe conditional cultivator and processor, I think you had to sign the attestation.
This one's interesting. This next one.
Has been disciplined or sanctioned by a state or federal agency.
Oh, no, sorry. I meant the charitable contributions, but that one is interesting too.
Yeah, or has any state or federal tax liens against their property. A list of charitable contributions by the applicant in the last 5 years. I do think that's interesting for one reason.
The nonprofits.
Well, sure, right. And then also, when we applied for CARD, we were forming new entities, and those new entities are the applicants. So the answer was always, despite the client, the person making contributions, the answer was always no, there was no contributions because the applicant was the entity that we formed last week.
Yeah, no, for sure. That's true. Yeah, just defining as applicant is definitely a savior. Especially because, if you donated to any of these 25 nonprofits that have card licensees, what does that mean?
Mm-hmm.
It's just a very interesting loophole that keeps happening.
PPI is fun. Designation of each portion of the application that the applicant considers to be exempt from disclosure under FOIL, including but not limited to certain trade secrets or commercial information. A copy of the labor peace agreement between the applicant and a bona fide labor organization, and an attestation that the applicant understands that the maintenance of such labor peace agreement shall be an ongoing material condition of the license. Important. That means, unlike every conditional licensee who had to get a labor peace agreement within 6 months of getting the license, this requires a labor peace agreement with the applicant. So when you apply, you need one in place. And just to clarify, a labor peace agreement is not unionization. It is essentially that you will allow a union to come on and talk to your employees, and you won't harass them, and in return, they won't harass you. It's literally what it says, a peace agreement.
Although I will say this, every single RO is unionized now. Did you know that?
I did.
I just found that out recently.
Interesting. And any other information requested by the office. We have 5 minutes left. Should we keep going? Any questions? We want to make sure that we answer any
Yeah,
questions. If anybody has any.
I'm scrolling ahead just to see where we're at here. Yeah, I'm happy to, maybe let's just finish this page.
Sure.
And then we can take a pause, and if there's no questions, call it a day.
All right. Continuing on. Criminal history and legal proceedings for the applicant and its true party of interest other than its passive investors or otherwise determined by the office. Fingerprints in a form and manner as specified by the office for purposes of obtaining a criminal history report from the Division of Criminal Justice Services. Fingerprints submitted shall be transmitted to the Division of Criminal Justice Services and may be submitted to the Federal Bureau of Investigations for state and national criminal history information checks. Information regarding legal actions, including but not limited to, important, as we learned in CARD, pending legal actions, whether civil, criminal, or administrative in nature, and a brief description. Any settled or closed legal actions, whether civil or criminal, against the applicant in the past 10 years. Any judgment within the past 10 years, including the court case name, case number, summary of the facts, the cause of action, and what the final ruling or determination was from the court administrative body or other tribunal.
I can pick up if you want.
Sure.
Jason. Any judgments within the past 10 years, including the court case name, case number, the summary of the facts, the cause of action, and what the final ruling or determination was from the court administrative body and or other tribunal. Any order, judgment, or decree of any court, administrative body, or other tribunal of the competent jurisdiction permanently or temporarily enjoining it from or otherwise limiting its participation in any type of business practice or activity within the last 10 years. Information of any bankruptcies, voluntarily or involuntarily, assignments for the benefit of creditors, appointments, and a receiver or custodian, or similar insolvency proceeding made, commenced, or pending during the past 10 years, and by or involving any applicant. A description of any delinquencies in the payments of any fees or taxes required under any state or municipal law within the past 10 years, and a description of the circumstances for any payment not made because of dispute regarding those the payment of those taxes or fees. So here's an example, like as a small business, learning how to stay on my quarterly tax reporting. Like I definitely have been a day late before on submitting my quarterly tax report. Is that something I'll have to report and go back in through? And so it's just kind of looking at, I read that as yes, I would, and have to provide a description of, oh, I forgot, or I missed the deadline. Actually, today is the final day for all those small businesses out there. December 20th, 2022 is the last day to submit your quarterly tax reports. So just an important thing to note. Evidence regarding good moral character, which may include but not be limited to the applicant's criminal history information, court documents, arrest reports, accusatory statements, and fingerprint responses. So that was all the stuff that they may request and look. And I think maybe we can pause this here. It's kind of.
Jason, do you think that they're going to require all this for, so this is where the TPI gets interesting, right? So like for people who are decision makers on the org chart, but are not technically any percentage interest owner for an applicant, do you think they're gonna have to do like fingerprints and everything like that for this?
I think so. I mean, I was recently dealing with one application where because the directions were kind of unclear, we submitted the head of a department as the TPI and her spouse. Even though it wasn't 100% clear, but I think it's just better to kind of, err on the side of caution, because the worst thing that's going to happen is OCM is going to say, we don't need it. If not, because these licenses are issued on a rolling basis, they could come back to you and say, hey, you know what? We need this. And then suddenly your application now dropped to the bottom of the pile because everybody who had everything in moved ahead. So err on the side of caution is, what I always try to do.
We got a question in the chat. Todd, thank you. Does anyone know if a possible farmer with a greenhouse who gave the town where it's located a letter saying it would not grow cannabis to approve the construction Would that hold still? In the regs, I think it said a municipality cannot deny. I'll leave that to Jason or Lee.
There's no opt-out technically for a municipality to say or deny cultivation, processing, or distribution tier. Obviously, they have that right within the dispensary on-site delivery tier. Basically, what the law says is you can't create an environment in which it's impossible for these businesses to really survive in that tier process. Are you asking as a town that doesn't want any cannabis at all growing, processing, or distributing? If anything, I would suggest talking to the Office of Cannabis Management if you're part of the town and saying, hey, we got this letter. What is within our parameters to limit for zoning? That's definitely within your right.
All right, cool. With that, it is officially 1:16. I'm going to say we'll wrap this up. Appreciate everyone being on the call. Hopefully today was helpful. Elise, thank you so much. Jason, thank you so much. Big shout out to the organizations who are helping put this on: CANY, the Cannabis Association of New York, and the Rochester Public Library. Make sure you invite your friends, share the link, share any of the recordings. The point of this is creating accessibility to the foundational information we all need to make the right decision moving forward in this industry. So again, thanks for everyone's time. We look forward to seeing everyone on Thursday at noon. So the 22nd of December at 12 p.m., the same spot, same time, hopefully same people. Everyone take care. Have a great afternoon, and we'll see you soon.